Before any rule speaks about artificial intelligence, an older one already governs much of what these systems do. The law that protects personal data, an agentic system that screens a payment, answers a customer, supports a claim, or sorts an application, often runs on personal information or reaches it quickly once connected to enterprise systems. The moment it does, the data protection regime of every territory whose people it touches already matters. For most enterprises, this is the part of the landscape that binds first and often binds hardest because it is settled law with regulators long practiced at enforcing it, not an emerging framework still finding its feet. These regimes share a common spine, whatever their local name. Personal data may be collected only for a stated purpose and used only for that purpose. People hold rights over their own data to see it, correct it, and in many places have it erased. An organization must hold only what it needs, keep it only as long as it needs, and stay accountable for protecting it. Two of these press hardest on autonomous systems. The first is purpose. Data gathered to run a customer's account cannot be turned without fresh grounds to training a model or feeding a decision the customer never anticipated. An agentic system that pulls freely from every source it can reach is exactly the behavior purpose limitation restraints, and the boundary we drew earlier has to encode that restraint, not just an appetite for more context. The second is decisions made about a person with no human in them. Many data protection regimes give people a specific protection against consequential decisions taken by automated means alone, a right to be told, to object, and to ask that a person look again. For a system built to act without waiting for a human, that is a direct design constraint, not a footnote. Regional variance here is real, and it is a planning problem more than a philosophical one. The territories you operate in will differ on what consent requires, on what safeguards are needed before data may cross a border, on whether certain data may leave the country at all, on how long records must be kept, and when they must be destroyed. A system designed around one jurisdiction's assumptions can break the rules of the next simply by moving data the way it was built to. For an enterprise that runs across borders, as our example does, data protection is therefore not a single control, but a set of them drawn per territory and enforced in the architecture, so that where data lives and where it may travel is decided by design, not discovered in an incident. This sits early because it is the floor the rest stands on. You can satisfy every AI-specific framework and still be unlawful if the data underneath was gathered or moved wrongly. For systems that consume more data from more sources, faster, and with less human pause than anything before them, this is the ground that has to hold first. There is a common assumption that agentic systems sit in a regulatory gap, waiting for AI-specific law to catch up. For most regulated enterprises, this is false, and the mistake is expensive. Long before any AI statute applies, the enterprise is already supervised by the regulator for its industry. And that regulator does not govern technology in the abstract. It governs the activity. A bank is accountable for every lending and payment decision, a hospital for every clinical one, an insurer for how it prices and pays a claim, whether a person, a rule, or an agent reach the result. Putting an autonomous system behind the decision changes nothing about who answers to the supervisor for it. This reorders the priorities because the sector regulator often binds sooner and may bind harder since its expectations are enforceable today. A financial supervisor that already requires sound technology risk management, an explanation for a declined application, fair treatment of customers, operational resilience, and a clear line of accountability has, in effect, already regulated the agentic system without naming it. What the sector regulators add is specificity. The general frameworks speak about high-risk systems in the abstract. The sector regulator says precisely which decisions are high risk in this industry and what evidence it expects. In finance, that is the supervision of credit, fraud, anti-money laundering, market conduct, and operational resilience. In healthcare, patient safety and clinical validation. In critical infrastructure, continuity and systemic failure. And there is a sharper edge for an enterprise running across borders, as our example does. The same capability can meet a mature, prescriptive supervisor in one market and a lighter one in another, while your own standard has to satisfy the strictest regime you touch. A payments agent that clears comfortably under one jurisdiction's rules may breach another's expectation on explainability, record keeping, model oversight, or keeping a human in a particular decision. So the leadership point is plain. Governing an agentic system is not only an AI governance exercise run by a new function, it is the extension of the supervision the enterprise already lives under into a new way of producing the regulated outcome. Risk, audit, and compliance do not hand that responsibility to an AI office when an agent takes over the decision. They keep it, and they have to understand the system well enough to keep answering. Next, how to read the whole regional landscape and where it is all converging.